going to talk about, I'm going to take all the questions that are on the channel. Anyone who is joining live can ask this any questions they have. I have some time now, maybe a short live, but I will try to answer mostly all the questions on the channel. So the first question, user, hello sir, I've done my master's in data analytics, but so you are unable to secure a job. You've done some master's in data analytics and you work part-time in a restaurant. A takeaway is offering you a sponsorship. Sponsor as a chef. Can I will get the skilled worker visa? So is new small business. So yeah, new small businesses can get sponsor license and they can also sponsor employees. So there is nothing stopping new businesses from employing sponsored migrants. But they may definitely have to show a business case as to why do they suddenly need a migrant, and that to someone who doesn't have experience being a chef. So just be mindful of that when they apply for the sponsor license, or even when they apply for, if they apply for any allocations for the cost to assign it to you. They should have a proper genuine setup, genuine business. There should not be selling of any skilled worker certificates, visas, etc., etc. Home office has been seeing a lot of these issues. They are not very happy with, especially the care visa area, this chef area, builders and all. So there are specific categories, and chef and restaurants are also in the high risk area. So yes, takeaways can sponsor migrants, and small new businesses can also sponsor migrants. So yes, it is possible, but it has to be, everything has to be genuine, and the business has to be a case as to why they want to sponsor you, a migrant, straight away as the first instance. Okay, live questions. We got defined cost today. How much time it take to assign it to the employees? If you got defined costs, you can just log in and assign it within 5 minutes. So that's what you got. So you got the approval of the defined costs. That's what I understand from your statement. You can assign it to the person immediately as soon as it is the defined cost is approved. Next question, mail Saya, how do I send you question? Can I send it here now? Yeah, so this live is only to answer questions summarily, which I can answer up to within a minute's time, not a detailed immigration advice. This is only a guidance live where I would guide and direct things. So yeah, or if you want detailed immigration advice, you should book a consultation either with us or any other immigration lawyer. The next question on the channel is, uh, would you love would love to ask you, any settlement partner going to apply for spouse visa outside UK? We just got last 6 months council tax for the rent flat as she pays it by a month. Is that okay problem? Yeah, so what I understand from your question is your question is on the property accommodation report, which is not required. So I will anyways point that out. So for spouse visas and all, or any family route visas, property accommodation reports are not required. I have a special video on that which I have explained everything on that. On that, you are asking a question, 6 months of council tax, flat rent, etc. Yes, that should be fine. If you have rented the flat for 6 months, you have 6 months of council tax bill. That should be fine. I don't think that should be an issue with the accommodation requirement for the family route visas. So, question, Malaysia partner and I applied for leave to remain under family and private life route. He's an overstayer. We have a British citizen child together. Have been waiting for 4 months. British citizen child together. You are applying as a parent, partner with parent exemption. Okay. So what is your question basically? I understood the facts of the question that you have applied. Yeah, there is a waiting period for parent exemption that you are applying. Those applications under the standard process may take up to, I think the latest update I had last week was 10 months or so. So about 9 or 10 months is the waiting period for those applications that you have done. I understood the facts. Okay. Okay, Tile, is the visa success guaranteed after course issued, because they have CV as well? No, visa success is not guaranteed at any stage. Home Office has been researching individuals at various stages, uh, starting from the sponsor license to applying for DCOS to applying for the skilled worker visa and also an entry clearance on some cases. I know employers have themselves told me where for these care worker visas, the restaurants and these builder job codes, etc., where they have also questioned the employees at the airport. They have checked their WhatsApp messages to make sure that there is no wrongdoing involved. Everything is genuine. So the genuineness test can be applied at any time unless you have landed and started work. I think that's what I would say for any entry clearance applications. You are still at risk. So next question, Toby. I failed a module but completed my 1 year course date stated on my CAS. Can I use PGDB to course? Uh, but completed 1 year course. Okay. Uh, uh, Sorry, I said on my CAS. Use a PGDB course or apply using for a PSW route. Okay, yeah. So if you have completed your course but you have failed and got whatever that PGDB or lesser than the course, whatever degree that was, you can apply even if you failed the course, provided you have completed the course, paid all the fees, attended the college, everything as per the compliances of the student visa. Applying using the 42 days PSW route. Yeah, so I'm not sure what you mean the 42 days PSW route, but then I think the 42 days that you are referring to is on my video where you have the 42 days to enroll your biometrics if you are doing it by the visa application model and not through the app. Yes, so if you are meeting all those timelines, you can apply. But then, yeah. So the first question, yes, course completion unsuccessfully is fine. You can apply for, but then you are trying to apply for a PSW. I don't think that is correct. You cannot apply if you have failed in your course for a PSW. The course completion failure is allowed only if you are switching to a skilled worker visa. That's my caveat. Okay, so is this considered as a parent visa application or for both since we live together? Because I believe parent visa don't apply to him as we are in a general relationship. Yeah, so it is a partner with parent exemption. That's what it, they will not decipher it. You ask Home Office and no caseworker will be able to decipher it, whether it's a parent visa, spouse visa, whatever that is. But in normal parlance, that's what we call it, spouse visa or partner visa with parent exemption. That's what he will get it under the 10-year route to settlement. That's what you're applying. Name doesn't matter, the rules apply the same way. Okay, thank you, Tyrell. Also, define FLRFE if you are applying for the first time. Does this apply to you or is it only called leave to remain application? Yeah, it doesn't matter. Home Office is really getting out of those all those names FLRFE, FLRM, FLR, whatever that is. I think the form straight away goes. I was checking one application today only. It's family root application. You keep on answering the questions. They will apply the rules, or if you have a lawyer, the lawyer will explain under which category they are applying. Like when we do our legal covering letter, we tell the caseworker this is what the rules apply and this is what you should apply. So that's what the lawyer's job is if you have a representative. And ideally, if nothing has been explained, the caseworker will go in the modeling of 5 year route first consideration. If that doesn't meet, they will try to apply the consideration for 10-year route. Yeah, then form names really doesn't matter. We don't even care about what those names are. So even home office doesn't care much. It's more what the main thing is what immigration rules apply to your case. Okay, next question that is live on the channel. Early concession will be requesting. So at my next extension, would I need English B1 test? Okay, so early concession. Yeah, for ILR, if you are between 18 and 65, and you will need the whether you apply under the ILR concession or whatever that is that you are talking about. I understand the private life route you are referring to ILR concession. You will need to meet the core requirement, English language and life in the UK. You will have to meet the requirement. Okay. Thank you, Mail Thiwa. I applied for defined cost, but the Home Office asked me to sign an employment contract, but I am yet to identify one. Can I send a draft contract without the name of the person to be sponsored? You are applying for a defined cost. Yeah, if you, for a defined cost, if you have not identified, yes, you can send it. There is nothing stopping you from that. But then the approach would be, why do I need a defined cost? I want someone from outside the UK. So you may have to show some other evidence also as to you have a role, you are trying to create a cost for it, defined cost, and you're trying to keep it open. maybe do some labor market testing, advertising, etc. You can send it anyways, but they may come back with further questions. You can send that draft contract without any name on it. That is perfectly fine. The rules will does allow you, and that's what they also state in their email. Please provide a draft contract of employment, even if it is not signed. So if you have not identified an employee yet, you can send that draft contract and take it from there. But to maintain a genuineness of all the things, maybe you should try to do labor market testing. May not be as per the rules in the past, but uh, yeah, some advertising, some efforts to find a local employee. So that is something that I would recommend. But yeah, you can do that without it. The rules don't ask you. But I know that case workers always go behind the rules and they try to check the genuineness of everything. So you can send them the draft contract. That is my answer. Good evening. I'm from Nepal. I'm Chinese cuisine cook. How to apply, sir? Can you help me? Okay, yeah. So if you the question is from Gyan from Nepal. You are a Chinese cuisine cook. You should apply directly to the restaurants who want you as an employee, and they should be able to help you with sponsoring with your work visa if they are interested. Next question. I went to the UK on September visa. I moved to a European country. February visa illegally. I got an email from you. And I've been withdrawn because do I get any ban? Can I apply for visit visa after 1 or 2 more years? Okay, so the question is you entered the UK, Rashid Ali, you entered the UK on a student visa, left and entered illegally some EU country, European country in a lorry, and obviously you are withdrawn from the university, you got an email. Your question is, can I apply for the visit visa after 1 or 2 years? You may apply because you have not broken any UK immigration rules. You left the UK borders within your validity of the visa. Though you have been withdrawn from the course, it doesn't matter. You are not in the UK, so that doesn't affect you. You can apply for the visit visa in 1 to 2 years, but make sure that you have enough justification for your illegal entry in another country, if whatever the reasons were. So that may come into play, that may affect your the decision. But yeah, you can apply for the visa. The withdrawal from the university, leaving the UK, doesn't affect your future applications. Okay, next question. Okay, live question. Can we change jobs while on a skilled worker visa? Yes, you can change jobs while on a skilled worker visa. Next part of it. Do we need to pay immigration and visa or insurance fee again if we just update the employer on the visa? Yes, you have to pay everything again. It's as good as making a new skilled worker visa application from inside the UK. You get some proportionate refund of the immigration health surcharge that you paid previously, whatever you have not used, whatever period of visa you have not used. But then you have to make payment of all the fees again, immigration health surcharge and the visa fees. Okay, thanks so much. Next question on the channel. If I worked on a contract for services for the past 10 months, paid weekly, now I am in salaried employment. Or this is for a spouse visa financial requirement question. Usually for this, always take immigration advice. I'll try to answer briefly in a minute. So your question is, you had two employments. First one was for 10 months. You are saying contract for services. It looks like it was self-employment, but you cannot combine self-employment with employment. It's a very tricky one. So if that is the case, if that was self-employment, you should have filed your taxes and all of that. Minimum 12 months. You worked only 10 months. I'm not very sure what is that you're referring to by contract for services. If it was self-employment, then it may not work out with your salaried employment. It is 10 plus 2 you have referred. But if it was salaried employment, then it is possible 10 months of salaried employment in the previous employment and 2 months in the current employment. 12 months, the categories don't matter. I know you're talking of category A or B. Yeah, you may come in the category B in both roles and over 40K. Yeah, if you're meeting the financial requirement in category B, the way you meet is your current employment, you should be paid at least 18,600 or higher. You'll need a letter from the employer confirming that, your latest payslip, latest bank statement, etc. And you have to show that in the last 6 months, last 12 months, you have earned at least 18,600 or higher by showing all the payslips, all the bank statements, and any contracts of employment you had. This only applies to salary employment. I don't understand what you mean by contract for services. It appears that is self-employment. That may not be possible. So next question, live. I completed the 1 year stated on my course. I re-enrolled and failed again. Wanted to apply for a withdrawal and settle with my postgraduate diploma. And apply with course with that. Did the 1 year stated on my CAS. So you completed your course of study. I re-enrolled and failed again. When you say you re-enrolled, did you get a new CAS or what happened? Did you get a new course start date and course end date? If that happened, then you would have to complete that course end date. I'm not sure what happened with, you said you re-enrolled. So did you get a new CAS with the start date? No CAS. Okay. I want to apply for a withdrawal. So I want to apply for withdrawal and settle with my postgraduate diploma. So you want to settle with your postgraduate diploma. So I don't think, to the best of my knowledge, that's whatever you did, you re-enrolled and did not continue. So I'm going to ignore the second part, which as good as not happened. So the first part is you enrolled in a degree course, whatever that was, and you got lesser than that. You will not be eligible for a PSW. That's my answer on that, just on that information part. So you will not be eligible for PSW. Now let me think of, can apply with costs with that. So you mean a skilled worker visa. Cannot get PSW, but can I get, you should be able to get a skilled worker visa because you have completed your course of study technically, even if you failed or whatever you did. Yeah, but still maybe take the advice, a proper advice of an immigration lawyer. But from the facts, I think you can apply for a skilled worker visa. Next question. This is only a guidance channel, so this is not immigration advice. If unless I'm instructed, it doesn't amount to immigration advice. This is just general advice to help you all out with whatever I can. Okay, so thanks so much for the video. Okay, info, please will the home office be aware if I do not pay my taxes or NI during the 5 years of my stay on a tier 2 visa? Yeah, so the question is, if you don't pay the taxes or NI for the last 5 years on the skilled worker visa and you try to apply for ILR, I think Home Office will easily find it just by running your NI. They have the HMRC system now because of the Brexit and the EU settlement scheme. They have access to HMRC records. So I don't think it will work out. That's my opinion. They would definitely do an NI check. It doesn't take even 2 minutes to do the NI run for them. Yeah. So if no taxes have been paid, no NI has been paid, they will definitely question the fact that whether you have been working in the last 5 years or so. And you will anyways need a letter from your employer confirming that they still need you for the employment in future. So it will also fail on that, or the employer is just lying to home office and then the employer has issues of getting an audit and being their sponsor license being cancelled. Okay, anyways, Mohammed, if the duration of next live question, if the duration of skilled worker visa granted is 5 years, we change job after 1 year and we will need to apply for 5 years visa again to update employer, or we apply for 4 years visa. You can apply for 4 years visa, but make sure you tell your new employer that you want the work start date and work end date to be 4 years. That's very, very important. So make sure you tell your employer that you only want sponsorship for 4 years, and then you can apply accordingly for the 4 years visa. Mr. ID applied for the administrative review since 14 months. My visa was revoked. What should I do? Why there is so much delay? I emailed them. Team. Yeah, admin reviews are going more than 12 months, 18 months, even 2 years. I know that because all the admin reviews of USS and all of this have been combined. There is a lot of delay on the admin review front. There is not much that any lawyer can do here. We've checked this with home office, followed up with that, and I know this is the same answer that we've got. They have a lot of delays. That's what I can confirm. What you're saying is right, and you're not the only one. I know it doesn't help, but I don't know what is your case, what are the facts of your case, whether there is any merits of success of your admin review. I don't know what the issues are. Maybe speak to an immigration lawyer, and if you want to consider the next course of action, you should definitely speak to an immigration lawyer or keep on waiting for the decision on the admin review. So What if I don't want ILR? Yeah, on the question of Astro, if you are on skilled worker visa for 5 years, you don't pay any taxes. Home office will be aware, but whether they will check every day or not, that's not. I don't think they do check every client, every person every day. They may check it when you make an application, or if there is an audit of your employer, they may check all the employees. There are different triggers that happen. But then, yeah, they may or may not come to know whether you are paying taxes or not, whether you're working for your employer or not. Especially these all checks happen at any trigger points. You are entering the UK, some research is done, sponsor has compliance audit being done, either the remote audit or the in-person audit. Many reasons trigger the home office checking your records. Yeah, and then if you just leave within 5 years, that is fine. I don't think home office will keep on checking and running after you if you have not paid the taxes or worked in the UK. Uh, okay, thank you, Rami. Raza ILR. Next question is super. As ILR applicant who has EA during my tenure years. I have been waiting for a year for my result. And yeah, why the come over so long? Okay, so this the question is about exceptional assurance. That is, there is a video that I've explained for the 10-year long residence whether COVID related exceptional assurance period counts towards it. Uh, in that one, your question is ILR applicant who has you have exceptional assurance during your tenure. You have been waiting for a year for your result. I don't know what result you mean. Were you waiting for the result of the exceptional assurance decision from Home Office? Then that will help. I don't think that should be an issue. If they have given you a positive decision at the end, then it should be fine. That 10 years, 10 months delay should be fine. Uh, Waiting for a year, yeah. Any idea why it took Home Office so long? Yeah, for the COVID, there were a lot of delays. Home office sometimes was not giving decisions 3 months, 6 months. I don't know why in your case it was 10 months, but if it was because of them, you applied the exceptional assurance within time, that within the period when you had a valid leave visa, or you were within a valid period of exceptional assurance and you applied for it, then you should be protected, even if home office took 10 months for your exceptional assurance decision. Next question on the channel. So this is about additional work for skilled workers. It is mentioned you can also work 20 hours a week. Yes, you can work 20 hours in another job or for your own business as you are still doing the job you are being sponsored for. Must be then so here business means can be self-employed and do a side hustle freelancing 20 hours. Yeah, so the 20 hours, I don't think the home office interpretation of those extra 20 hours is you can be self-employed. When you're on skilled worker visa, you cannot be self-employed. So that interpretation is wrong. You cannot be just doing freelance and all. You should be employed getting a salary. That's what they mean with the additional 20 hours. Okay, thank you. And now I will end this live. There are no more questions till this point. I have covered, and I will cover the questions in the next live. Thank you very much everyone for joining.